Good morning, Young Arif. May it please this Honorable Court, my name is Nur Afrina Safia, appearing as the Senior Counsel on behalf of the appellants, Azlinda binti Ahmad, Ashim bin Abdul Majid, and Aina Cik Mat Daud. Appearing together with me today is my learned co-counsel, Filiza Hidayati. On behalf of the respondents, we have the learned counsel, Mr. Rajesh Shahril, and he will be assisted by his co-counsel, Miss Aina Hazimah. Young Arif, we wish to put forward two arguments. I'll be dealing with the first issue within 15 minutes, and the remaining submission will be dealt with by my co-counsel for another 15 minutes. We will also reserve 5 minutes for rebuttal session. Before we proceed, allow me to assist this honorable court to the facts of the case. This is an appeal from the decision of the learned judge of the High Court after a full trial involving the case of land purchase, damages claimed by the appellants, and status of ownership of the said land. In this case, the appellants were the registered owner of 22 acres piece of land worth Rm 15 million, which located in Menglembu, Kota Kinabalu. In order to sell the said property for a price of Rm 2.50 million, the appellants had engaged with Mr. Tony, a real estate negotiator, to sell the said property to any prospective purchaser. Together with that, Mr. Tony had received the custody of title deed from the appellants for safekeeping. However, the appellants later discovered that the respondents had become the registered owners of the said property under a sale and purchase agreement executed on 12 February 2021. The appellants later argued that their signatures in the said agreement were forged, together with the power of attorney and the memorandum of transfer. In addition, the said land was littered with respondents' rubbish. The appellants asserted that they were amid entering into a sale and purchase agreement to sell the said property for Rm 3.0 million with Mr. Wong. This agreement was scheduled for execution on 15 March 2021. However, subsequently, the appellants had lost the value of their prospective investment to sell the said property to Mr. Wong due to the existence of the said sale and purchase agreement entered by the appellants and the respondents, which was executed without the knowledge of the appellants, the owners of the said property. This is the hearing of the appeal against the decision of the first instance hearing. The learned judge held that the respondents are the new co-owners of the said property by reason that they were bona fide purchasers for value without notice. The learned judge also dismissed the claim for damages of Rm 500,000 for loss of prospective investment and a declaration that the appellants are still the registered co-owner of the said property. Young Arif, having finished with the facts of the case and the subject matter in this appeal, therefore, I shall now proceed with my submission. There are two issues to be submitted before this honorable court. First, the appellants are entitled for damages of Rm 500,000, and second, the respondents who were not bona fide purchasers did not obtain good and not indefeasible title to land immediately upon registration of the transfer, and therefore is defeasible registered interest in land. I'll be submitting on the first issue, and my co-counsel will be submitting on the subsequent issue. I'll divide my first issue into three parts, which are: first, the sale and purchase agreement entered by the appellants and the respondent is void. Second, the respondents have committed trespass to land by littering rubbish on the said land. And lastly, the appellants have suffered loss of opportunity to sell the said land to Mr. Wong Chin Chai. For the first ground, Young Arif, we submit that the sale and purchase agreement entered by the appellants and the respondent is void. I would like to draw this honorable court's attention to the relevant laws and cases. By virtue of Section 19, Subsection 1 of Contracts Act 1950, it is said that any agreement is voidable if the consent to the agreement is derived from fraud. The term fraud in this provision includes any act fitted to deceive and is declared by law to be fraudulent as stipulated in Section 17, Paragraph D and E of the Contracts Act 1950. Young Arif, if I may bring this honorable court's attention to the moot problem, page 2, paragraph 5. The appellants contended that their signatures in the sale and purchase agreement, the power of attorney, and the memorandum of transfer were forged. In relation to the power of attorney in this case, the Court of Appeal in Sidang Baram Anak Lelaki Torosami and Lot B. Yong defines that power of attorney is a document by which someone confers power or authority to another to act on behalf of him. Under this circumstance, the law applicable is that of agent and principal. For the term agent and principal, according to Section 135 of the Contracts Act 1950, an agent is defined as a person employed to act on behalf of another, with the function to deal with third person. The person who represented by the agent is known as principal. Subsequently, in the case at hand, the appellant as the owner of the land which looking for a prospective purchaser is the principal, while the one who was appointed through the said power of attorney to arrange the sale and purchase of the said land on behalf of the appellant is an agent in this case. Further, according to Moot Problem, page 3, paragraph 9, the learned High Court had decided that the power of attorney used to transfer the land was forged. Hence, it is clear that anyone who has been appointed to act as an agent representing the appellants through the said power of attorney, including the signature in the agreement, was also forged. This is due to the fact that everything in the document was provided by the agent. Furthermore, in relation to the forged signature, as conferred in Section 463 of the Penal Code, when there is any false document or false in any part of the document made, it will be regarded as forgery when the intention is to cause any person to lose their property or with an intention to commit fraud. Having regard to the relevant provisions of the Contracts Act 1950 and the authorities upon the subject, the following proposition is considered to be settled and beyond argument. In applying to the case at hand, forgery and falsification of documents, including a forged signature, are part of fraud. Accordingly, Section 19 of the Contracts Act 1950 applies. The sale and purchase agreement entered by the appellants and the respondents which involves forgery is rendered voidable due to the existence of element of fraud in it. Yang Arif, although the party whose consent was caused by fraud may opt to insist that the contract shall be performed or continued, it was clear that the appellants have no intention in insisting that the contract shall be performed, since they had intended to sell the land to another property. Consequently, we submit that the said sale and purchase agreement is void, and thus the respondent is neither the purchaser nor the owner of the land. As for the second ground under this issue, Yang Arif, having established that the said agreement is void and thus the appellant's ownership on the land remains, we would like to submit that the respondents have committed trespass to land by littering rubbish on the land. We would like to bring this Honourable Court's attention to the relevant case, which is the case of Tenaga Nasional Berhad and Bukit Lenang Development Sendirian Berhad. It was stated that trespass onto land is an unlawful direct and immediate interference to the land that in possession of another. Additionally, in Gregory and Piper, it was held that throwing or placing rubbish at one's place without authority is trespass. To apply on this instance, having established that the sale and purchase agreement entered by the appellants and the respondents is void due to forgery, the respondents are not in possession of the land since his purchase of the said land through the agreement is invalid. Thus, the appellants were at all material times in possession and the owner of the said land. As such, we submit that the act of littering rubbish committed by the respondents on the said land should be seen as trespass, since the act was done on the appellant's land other than it has violated the owner's right and possession of the land. For the last ground for my submission concerning the first issue, Yang Arif, we submit that the appellants had suffered loss of opportunity to sell the said land to Mr. Wong Chin Chai. The aim of damages as stated in the case of Liu Choi Hung and Shah Alam Properties Sendirian Berhad is to place the injured party in the position as he would have been if the wrong is not occurred. Due to that, one could claim for compensation. Further, in the case of Ting Sieh Chung and Hock Peng Realty Sendirian Berhad, the appellant in the case was awarded for damages for loss of opportunity to sell his property to the other party. The losses suffered were due to the respondent's caveat on the land. To apply in the present case, the the appellants are the owner of the said land and thus possessing their rights to sell the land to anyone. Without the existence of the sale and purchase agreement entered by the appellant and the respondents, the appellants have been in a process to sell the said land to Mr. Wong Chin Chai for a price of RM 3.0 million as stated in the moot problem page 2 paragraph 6. However, in consequence of the said argument, my apologies. However, in consequence of the said agreement, the appellants had lost their opportunity to sell the land as well as the value of their prospective investment. These are losses arising from the agreement which has no consent from the appellants. Hence, we submit that the appellants are entitled to damages for the loss suffered as he could no longer sell his land due to the forged agreement. Should the forged agreement involving the respondents does not exist, the appellants could sell the said land to Mr. Wong and thus would not have suffered losses from it. As such, Yang Arif, we submit that the appellants are entitled for damages of RM 500,000 on the ground that the sale and purchase agreement entered by the appellants and the respondent is void. The respondent have committed trespass to land by littering rubbish to the land, and lastly, the appellants have suffered loss of opportunity to sell the said land to Mr. Wong Chin Chai. Yang Arif, having finished with the agreements for the with the my apologies. Yang Arif, having finished with the argument for the first issue, that shall conclude my submission. Thank you, Yang Arif, for your time and indulgence.
Good morning, Ya Arif. May it please this Honourable Court, my name is Finsa Hidayati, appearing as the Junior Counsel on behalf of the appellants. Yang Arif, having finished with the first issue submitted by co-counsel, I will now move on to the second issue, which is the respondents were not bona fide purchasers, did not obtain good and non-indefeasible title to land immediately upon registration of the transfer, and therefore is defeasible registered interest in land. I will divide my submission into two grounds, which are: first, the respondents are no longer the registered owner of the said land. Second, the respondent obtained the said land by void instrument of fraud or forgery. Yang Arif, now I will proceed with my submission. On the first ground, we submit that the respondents are no longer the registered owner of the said land. We would like to draw this Honourable Court's attention to the relevant provision that mention about the registered owner of a land in the state of Sabah, which is Section 88 of Sabah Land Ordinance, which it mentioned that no new title and no dealing with, claim to or interest in any land except land still held under native customary tenure without documentary title shall be valid until it has been registered in accordance with the provision of this part. Further, I would like to bring this Honourable Court attention to the relevant cases that pointed about the registered owner of a land in the state of Sabah. Yang Arif, in the case of Borneo Housing Mortgage Finance Berhad and Time Engineering Berhad, page 26, paragraph 36, this Honourable Court held that Section 88 of Sabah Land Ordinance highlights the critical importance of registration as a prerequisite for the recognition of the validity of title, dealing, claim to, or interest in any land. This section, according to the court, implies the underlying torrent notion that title to or interest in any land vests and devests only upon registration. Yang Arif, it was further discussed in other case. According to the case of Sia Hyong Ti and others, and Chong Sukong and others, page 201, paragraph 31, this Honourable Court stated that Section 88 of Sabah Land Ordinance simply deals with the registration of new title, dealing with any claim to or any interest in any land, except the land held under native customary tenure without documentary title. In other words, such title or dealing must be registered in order to be valid under the Sabah Land Ordinance. Yang Arif, additionally, the Supreme Court in Boy and Mayer of Wellington, page 1205, stated that The registered A's title cannot pass to B unless a valid instrument of transfer is registered against A's title. It cannot pass solely on the basis of registration without a valid instrument, nor can it pass solely on the basis of a valid instrument without registration. Hence, Yang Arif, we submit that the trial court is righteous in finding that the respondent were no longer of the said land. My apologies. The respondent were no longer the owner of the said land in Benglebu, Kota Kinabalu. Yang Arif, in the present case, the appellants in the first place discovered that the respondent had become the registered owner under a sale and purchase agreement. According to moot problem, page 3, paragraph 8, in the trial court, the appellant prayed for the court grants an order to expunge the respondent from the register. As provided in the moot problem, page 3, paragraph 9, the learned High Court judge in the trial court granted an order to expunge the respondent from the register on the ground of the power of attorney used to transfer the land to the appellants was forged and void instrument. Yang Arif, we submit that, as such, it can be established that the trial court is right in making such decision to remove the respondent from the register. Therefore, the respondent are no longer the registered owner of the said property as it has been removed by the trial court. Yang Arif, as for second ground under this issue, we submit that the respondent obtained the said land by void instrument, fraud or forgery. I would like to bring this honourable court attention to the relevant cases that mention about obtaining the property or land by void instrument, fraud and forgery. Yang Arif, the Federal Court in Borneo Housing Mortgage Finance Berhad and Time Engineering Berhad held that, despite the fact that both the Sabah Land Ordinance and the National Land Code 1965 are based on the Torrent system, there is no provision in the Sabah Land Ordinance mentioning indivisibility of title or interest in land, unlike in the National Land Code. Yang Arif, further, it can be seen in Sia Hyong T and others and Chong Sukong and others, page 26, paragraph 35, where the Federal Court held that Section 88 of Sabah Land Ordinance should be reviewed on its own without being overridden by the provision of the National Land Code because those two are different. It signifies that Section 88 of Sabah Land Ordinance did not address the issue of divisibility or indivisibility of title of the interest. This is further supported by case of Fraser and Walker, where the Privy Council stated that an indivisible of title cannot be acquired by the registration of a void instrument. In other words, for any fraudulent or forgery or void instrument, the registered owner is not entitled to indivisible of title on the said property. Yang Arif, similarly in Briswa and Wall, page 398, paragraph 89, this honourable court held that the respondent did not obtain an indivisible title upon the registration of the transfer as a result of the actual fraud of his agent. Yang Arif, in the case of Sia Hyong T and others and Chong Sukong and others, page 201, paragraph 30, this honourable court held that no one may acquire title, right, or interest from or through a forged instrument unless he fulfill the doctrine of bona fide purchaser for value without notice. The Federal Court in this case affirmed the trial court judgment that the appellant could not obtain valid title to the land since the power of attorney used as authority to transfer the land was a forgery. Therefore, Yang Arif, this honourable court ruled that the instrument of transfer in the current case was a void instrument of transfer since it was performed on the authority of a forged power of attorney, and so it could not give rise to a valid title in law. Yang Arif, we would like to draw this honourable court attention to the relevant provision which is Section 29, Subsection 1 of the Minor Offences Act 1955, whoever commit fraudulent can be liable to a fine or imprisonment does not exceed 1 year or both under this provision. As such, Yang Arif, we submit that in applying to the present case, as provided in the moot problem, page 2, paragraph 5, the appellants argued that the signature in the sale and purchase agreement, the power of attorney, and the memorandum of transfer were forged. As such, Yang Arif, the respondent were not bona fide purchaser for value without notice, as there was fraudulent and forgery instrument in the registration of the said land. Although there was a lacuna in Sabah Land Ordinance, it would not make an exception for the registered owner of the property if there were any fraudulent or forgery or void instrument contained in the registration of interest. Therefore, the Council for the Appellants respectfully requests this Honourable Court to declare and adjudge that, firstly, the sale and purchase agreement entered by appellants and respondent is void. Secondly, the respondent have committed trespass to land by littering rubbish to the said land. Thirdly, the appellants has suffered, Thirdly, the appellants have suffered loss of opportunity to sell the said land to Mr. Wong Ching Chai. Fourthly, the appellant are entitled to damage for RM 500,000. My apologies. Fifthly, the respondent are no longer the registered owner of the said land. Sixthly, the respondent obtained the said land by void instrument of fraud or forgery. Lastly, the respondent were not bona fide purchasers, did not obtain good, and not indefeasible title to land immediately upon registration of the transfer, and therefore is defeasible registered interest in land. Yang Arif, having finished with the second issue, if there is no further existent favour by this Honourable Court, that shall conclude my submission on the remaining issue. Thank you, Yang Arif, for your time and indulgence.
Good morning, Yang Arif. May it please this Honourable Court, my name is Raja Shahril Adnani bin Raja Shah, appearing as the Senior Counsel on behalf of our client, Megat bin Asbullah, Maharun binti Dahlan, and Minarwan bin Hanifah. Appearing together with me today is my learned co-counsel, Nur Aina Hazimah binti Kamaruddin. Yang Arif, we wish to put forward two arguments. I will be dealing with the first issue within 15 minutes, and the remaining submission will be dealt with my co-counsel for another 15 minutes. We will also reserve 5 minutes for the rebuttal session. Yang Arif, there are two issues to be submitted here before this Honourable Court. The first issue is the appellants are not entitled to damages 500,000 ringgit. And the second issue is the respondent who are the bona fide purchasers for value and without notice obtain the said property in a good faith and indefeasible of title. Yang Arif, I will be submitting on the first issue and my co-counsel will be submitting on the remaining issue. As such, I will divide my first issue into two parts. The first part is all elements of contract have been performed. And the second part is the appellants are not entitled to claim damages for loss of prospective investment. Yang Arif, for the first issue, we submit that the appellants are not entitled to damages 500,000 ringgit. On the first ground, we submit that all elements required to be a valid contract have been performed. If I may bring this court's attention to the relevant cases that I will highlight throughout my submission. In the case of Emas Kiara Sendirian Berhad and Michael Joseph Montero, receiver and manager of Lembah Beringin Sendirian Berhad and others, Farkol Estate, Sendirian Berhad and others interveners, the three elements that should be present in order to conclude that there is a contract formed are first, consideration, second, certainty, and third, intention to create legal relation. In the instant case, the said sale and purchase agreement dated 12th of February 2021 has fulfilled all the three elements of aforesaid in order to conclude that there is a concluded contract. Firstly, there is a consideration in the price transferred from the respondent to the appellants, which is the RM 2.5 million in exchange for a piece of land. Next, there is also certainty to the property, which is a piece of land held under CL 017-029-266, measuring 22 acres, located in the district of Mang Lembu, Kota Kinabalu. Finally, on the intention to create legal relation, even though the appellant contended their signatures were forged, but since the allegation was not confirmed and the trial judge was silent on that particular issue, it can be deduced that both parties have intended to create legal relations in the sense that the promise of each side are to be enforceable. Yang Arif, hence, we submit that the said sale and purchase agreement is a valid contract since all three elements have been fulfilled. Therefore, the appellants cannot render it to be void under fraud. Yang Arif, the second ground under this issue is we submit that the appellants do not entitled to claim damages for loss of prospective investment. Accordingly, in the case of Asian Banker Malaysia Berhad and others, and Shenkot Sendirian Berhad and others, the court held that it is right for the misled party that is seeking damage in a court of law has the burden of proving both the fact and the amount of damage before he can recover such damages. There must be proof of the damages claimed and not just a mere assertion. In the instant case, the appellants claim for 500,000 ringgit for loss of prospective investment. However, loss of prospective investment is not an actual loss. This means that the appellants are unable to prove damage since they did not have actual loss. In the case of in the case of Abdul Razak bin Dato' Abu Samah and Shah Alam Properties and another appeal, the court held under the damages for fraud, the misled party is entitled to recover all expenditure reasonably and properly incurred in consequences of and flowing directly from the fraudulent mispresentation. In this case, there is no expenditure properly occurred because at the time the appellant know that the respondent have become the registered owner of the said land, they were still amid entering into a sale and purchase agreement with Mr. Wong Chin Chai. In addition, even if there is any expenditure occurred, the appellant would still fail because their act was not because of fraud. This means that even if the fraud had never happened, they would still be trying to sell the said land to Mr. Wong. Yang Arif, we submit that the loss of prospective investment is not a claimable damages under the case of fraud as it is not an actual loss and the loss is not flowing directly from the fraudulent mispresentation. As such, Yang Arif, we submit that the appellants are not entitled to damages 500,000 ringgit. Since the sale and purchase agreement is a valid contract and the loss of prospective investment is not an expenditure properly and reasonably incurred in consequences of and flowing directly from a fraudulent mispresentation. Yang Arif, if there is no further assistance favored by this honorable court, that shall conclude my submission on the first issue. Thank you, Yang Arif, for your time and indulgence.
Good morning, Ya Arif. May it please this honorable court. My name is Nur Aina Hazimah binti Kamaruddin, appearing as the junior counsel on behalf of respondent. Ya Ahmad Arif, having finished with the first issue submitted by my co-counsel, I will now move on to the second issue, which is bona fide purchases for value and without notice obtain good and indefeasible title to land immediately upon registration of the transfer and is therefore an indefeasible registered interest of the land. Ya Ahmad Arif, for the second issue, we submit that bona fide purchases for value and without notice obtain good and indefeasible title to land immediately upon registration of the transfer and is therefore an indefeasible registered interest of the land. Ya Ahmad Arif, I will submit that the issue based on the ground, the respondent is entitled to indefeasibility of title upon registration for value and without notice according to the Section 88 of Sabah Land Ordinance. If I may bring this court's attention to the relevant cases that I will highlight throughout my submission. In the case of Borneo Housing Mortgage Finance Berhad and Tam Engineering Berhad, United Lands Development Sdn Berhad sought for a bridging loan from the appellant in March 1982 to finance an industrial development project on 4 parcels of land in Sabah. The respondent agreed to purchase an industrial building for the developer under a sale and purchase agreement. On May 1983, the developer created a charge on the land in favor of the finance firm, which was which was officially recorded under Section 104 of the Sabah Land Ordinance. On that date, the purchaser had paid the full purchase price, bringing the sale transaction to a close. When the developer failed to repay the debt, the finance business began legal action to enforce the penalty. As a result, an order for sale was issued on August 1991 and the property was sold to Kara Musim Jaya Sdn Berhad, which is the purchaser of the judicial sale, on November 1991, with a certificate of sale dated February 1992. On receipt of the full purchase payment, the court held that the developer was deemed to have become a bare trustee of the property for the buyer. Furthermore, the Federal Court also stated that the Sabah Land Ordinance has the influence of the torrent system idea that title to or interest in land vests and divests only on registration where it is implied by Section 88 of the Sabah Lands Ordinance. Therefore, the said land has been registered under the respondent's name. Under Section 88 of the Sabah Land Ordinance, it is clearly stated that once the said land is registered under a person's name, he or she is entitled to the indivisibility of title even without notice. In addition, the First Instance Court also declared that the respondents were a bona fide purchaser for value and without notice. Hence, the respondents did entitle the indivisibility of title since the said property had been registered under their names. Moreover, further discussion can be seen in the case of Betzwa and Wall. In this case, the judge held that the torrent system that have been influenced the Sabah Lands Ordinance 1930 is a system of title by registration rather than a system of registration of title. As a result, the respondents possess the said land by virtue of registration. Even the registration resulting from a void instrument, it is still valid under the provision of the registration. Thus, they had their rights to do whatever they want to the said property. It made the respondents as a rightful landowner by virtue of registration to the said land in line with the Section 88 of Sabah Land Ordinance. Hence, we submit that the respondent is entitled to indivisibility of title in line with the Section 88 of the Sabah Land Ordinance 1930. In light of the submission made above, the respondents humbly request the court to declare that firstly, the said sale and purchase agreement is a valid contract. Secondly, the appellants cannot claim for loss of prospective investment. Thirdly, the appellants are not entitled to the damages 500 ringgit. Fourthly, the appellant is not entitled to claim damages for loss of prospective investment. Fifthly, the respondent is entitled to indivisibility of title upon registration for value and without notice according to the Section 88 of Sabah Land Ordinance. Sixthly, the respondents who are bona fide purchasers for value and without notice obtain the said property in a good faith and indivisible of title. If there is no further assistance favoured by this Honourable Court, that shall conclude my submission on the remaining issues. Thank you, Yang Ma'arif, for your time and indulgence.
Yang Arif, the appellant has 3 quick points to rebut. First, with regard to the argument on validity of contract, it is submitted that there is little support for the argument advanced by the counsel for respondents. The respondents stated that the said agreement have fulfilled all 3 requirements that should be present in order to conclude that there is a contract formed, which are consideration, certainty, and intention to create legal relation as set out in the case of a mascara. Thus, the contract is valid. However, as for the third element, which is the intention to create legal relation, I would like to restate that since the power of attorney is forged, as what has been decided by the first instance court, everything that has been provided by the agent appointed through the forged power of attorney is forged too. This includes the signature which signifies an assent on behalf of the appellants. Since the signature or the assent were forged, we conclude that there was no intention to create legal relations between the appellants and respondents, hence the argument is void. Additionally, it is pertinent to note that Section 19 subsection 1 of Contracts Act 1950 provides that any agreement is voidable if the consent to the agreement is derived from fraud. It could be seen in this case that first, there is an element of fraud, which is the forged power of attorney, hence the signature provided is forged too. Second, the appellant had intended to sell the said land to Mr. Wong, and it is clear here that they have no intention to insist that the contract shall be performed and continued. Hence, we submit that the contract is void. Second, the respondents also contended that loss of prospective investment is not an actual damages. However, my apologies. The respondents also contended that loss of prospective investment is not an actual damage. However, it is important to observe the decision in the case of Ting Sieh Chung and Hock Peng Realty Sendirian Berhad. It was held that when the appellant lost his opportunity to sell his property to another party due to the faulty of the respondent, this is the damage he suffered. The appellant in this case was awarded for damages. The same law applies to this instant case. Should the forged agreement involving respondent does not exist, the appellant would be receiving some amount of money that is higher than the respondent's payment for the land. Yang Arif, my apologies. Yang Arif, my last point to rebut is an argument concerning title of the land. The counsel on behalf of the respondent stated that even the respondent had obtained the said property with forgery, the said property had been registered under their names. Thus, they had their rights to the property. It is due to the influence of the torrent system on Sabah Land Ordinance. However, Yang Arif, although there is the influence of the torrent system on Sabah Land Ordinance, the Honourable Court in Sia Hyong Ti and others, and Chong Soo Kong and others, held that no one may acquire title, right, or interest from or through a forged instrument unless he fulfilled the doctrine of bona fide purchaser for value without notice. Therefore, we respectfully request this Honourable Court to declare that the respondents were not indefensible of title in the said land as they obtained the said property by forgery or void instrument. With that, I shall conclude my rebuttal. Thank you, Yang Arif.
For the sole rebuttal against the learned counsel of the appellants, Yang Arif, I have 3 quick points to make. On the first issue, the learned counsels for the appellants allege that the forgery of power of attorney (POA) indicating that the SPA is also forged on the ground that anyone who has been appointed to act as an agent representing the appellants through the said POA is also the same person responsible for the creation of SPA. This assertion, however, is just a mere speculation with no direct evidence to show that the signature in the SPA itself was forged. In the case of Lee Cheong Fah and Su Man Yok, to claim damages under fraud, the plaintiff must prove beyond reasonable doubt that there is a clear, cogent, direct and unequivocal evidence of fraud. Fraud is not a matter of inference or mere simple deduction. Furthermore, in this instance case, there is no fact to show that both SPA and POA were prepared by the same person. Therefore, the forgery of POA has nothing to do with the validity of the signature in the SPA. Although it is known that Mr. Tony Leung Chee Wen had custody on the land title, but the respondent was never shown to enter the said SPA with Mr. Tony. Thus, the counsels for the respondents conclude that there is no proof to support the allegation by the appellants that they did not sign the state SPA. Furthermore, the learned counsels on behalf of the appellants also point out about the respondents have committing trespass by doing some littering rubbish on the land that the appellants believe belongs to them. In the case of Borneo Housing Mortgage Finance Berhad and Time Engineering Berhad, the state land is actually registered under the name of the respondent as accordance to the torrent system as well as in line with the Section 88 of the Sabah Land Ordinance, in which the section stated that any person who his name has been registered and gains such land even for value and without notice is said to be the landowner of the said land. In addition, it is illogical to say that the respondents had committed trespass to the land by doing littering because the land belongs to the respondents, not the appellants. Hence, it is up to the respondent to do whatever they want to the said land, even littering rubbish, because the land is registered under the respondents' names. Thus, the counsel of the respondent conclude that the appellants cannot argue that the respondent had committed trespass since the land does not belong to them. It is up to the respondent to do what they want because the land is theirs. For the second issue, Yang Arif, the learned counsel for the appellants also stated that respondents were not a bona fide purchaser. This allegation is extremely out of point as the issue here is not whether the respondent is bona fide purchaser, but rather whether bona fide purchaser receives indivisibility of title. The fact that the respondent was a bona fide purchaser was already affirmed by the trial court and is undisputed. Therefore, the respondents are bona fide purchaser and thus obtain indivisibility of title by virtue of Section 88 of Sabah and Ordinance 1930, where it is stated that any landowner who obtained the said land, even for value and without notice, is entitled to indivisibility of title to the said land. This provision further explains that the respondents also get the title since the land has been registered under their names. Hence, the learned counsel on behalf of the respondent conclude that the respondents get the indivisibility of title by virtue of registration to the said property. Thank you, Yang Arif.